So my audio's off, but I should probably turn my phone off because I noticed that some of these.
Speed on beat.
Okay, Karen. So can you describe from the start of the case that we're talking about, just give me a brief overview of the case?
This case resulted from two women who had been in a primary relationship together for about 5 years, and they decided they would have a child together. And one of them was inseminated, and they had a daughter. Before their daughter was born, they entered into a written contract, and that contract was a critical, different aspect than any other case that eventually had come before the court. While there were other cases in the past where lesbians had had children together that had been litigated through the appellate court and up to the Supreme Court in California, none of those previous relationships, except for one, and I'll discuss it in a moment, involved parties that had a written agreement about what they would do when their
Okay, let's cut for a second.
Do you want to start again? Should we start?
No.
Do you want to cut? You want to cut?
Okay, we're going to cut.
Roll on beat.
And we're going to start again from the very top.
Okay.
Okay.
So the background on this case. So this case involved two women that had been in a primary relationship for 5 years. They decided to have a child. Before their child was born, they entered into a written agreement. One of the women was artificially inseminated. The agreement contemplated that their relationship may end, and if it did end, what they would do in terms of dispute resolution, which involved both mediation, and if mediation was not successful, arbitration. They both wrote in that agreement that their intention was each of them, and another person, was sort of interesting, there was also a third party, would maintain a relationship with the child. The beginning of the agreement said that only the biological birth mother was a parent. But in the very next sentence, it went on to say they both intended to parent their child when the child was born. And this is critical in terms of what happened later in the litigation. So their daughter was born, and they raised her together as parents, held her out to be their child, were a family unit, and in every way represented to the public that this was their family, this was their daughter, and they were both parents. So flash forward, their relationship ends, and for a year after the relationship ended, they continued the relationship where both of the parents had access to their daughter. But then after a while, that broke down, and the biological mother said to the non-biological mother, you can no longer see our daughter. First, it was limited. You must see her under these particular circumstances, and then that changed, and it became more and more limited. At that point, I was contacted by the non-biological mother who presented me with this written contract and several pieces of writing from the biological mother saying to my client, you can only see our daughter under these particular parameters, and that she was limiting that, and that she actually wanted to end it. But if it was, my client could continue to see her daughter, but only if she did so under very strict parameters. So at that point, my client decided that she would litigate. She did try the dispute resolution process, by the way, but the other woman would not participate, so that did not happen. So I had a couple of options about what to do as a lawyer. One of those was I had a written contract that had an arbitration provision in it. So we wrote a letter to her, the biological mother, and said, you know, we would like you to participate in arbitration. Your agreement calls for binding arbitration. She said no. So that's a breach of the contract. So we filed a lawsuit in the civil department for breach of the contract and a motion to compel and enforce the arbitration provision so that they would go through that procedure and ideally get some sort of ruling that they could both live with, and it would be binding. That was the intention of the parties when they signed that agreement. Separately from that, my client wanted to go through the family law court, and we filed a complaint under the Uniform Parentage Act. So both of these complaints were filed on the same day, one in the family law court here in Sonoma County and the other in the civil department. And opposing counsel filed motions against both of those cases. One motion, and I won't get into the details of the motions, they're sort of very procedural and nobody but lawyers are going to be interested in all the details about that. But the long and the short of it was the motion in both cases involved whether or not my client had standing. What was her relationship to this child? So that was the critical juncture of where the law was back in the 1990s, which was the following. Unless you were considered a biological or a natural parent, whatever that's supposed to mean, by the way, you didn't have any legal relationship to the child. And back then, this was before you could become a registered domestic partner, and it was before you could adopt a child, and it was certainly before lesbian and gay marriage. So that's one of the primary reasons that these two women entered into this contract, is because they knew there was nothing under the law that gave my client the right to continue her relationship with her daughter if they didn't put something in writing, and if they went to court later, that it would be a significant uphill battle, hence the written agreement. So when that's violated, and then we get to court, and in the civil case, the judge ruled that my client did not have standing because she had no legal relationship to this child. And in the uniform parentage case, the same result, although the judge in that case was a little more warm and fuzzy in terms of his ruling. He said, I have to follow the law, and the law says your client doesn't have a relationship to this child. On the other hand, I would like these two, if they could at all, try and work this out outside of the judicial process. What was interesting about his ruling and the case law at the time that he relied on, and later the appellate court relied on, is that there was law at that time. It was the Johnson versus Calvert case that supported the legal argument that I was putting forth. I said to the court that you do have the jurisdiction to recognize my client as a parent under the Uniform Parentage Act. And the Johnson versus Calvert case, what was interesting about that case and the result in the case that I was litigating, the appellate result, is that in Johnson, the fact pattern was the following. It was a man and a woman who used his sperm and her eggs, and they implanted those in a surrogate. And the other woman had the child. And after that child was born, that woman sued to say, I'm the mother of this child. The critical aspect about Johnson versus Calvert is they had a written contract. They had a surrogacy agreement. And the California Supreme Court in that case ruled that both of the women were biological mother to the child, and the man was biological dad. So they all had this natural relationship to that child under the Uniform Parentage Act, but the court could not determine, without looking at the written contract, what the intention of the parties was. And that word, intention of the parties, was critical in the case that I was litigating. And why it's critical is because I said, listen, you have a written agreement between these two women, and it expressly shows their intent. They intended to bring this child into the world, to raise her as parents, and if their relationship defaulted for any reason, that they were going to have first mediation and then arbitration to try and resolve that. But in any event, they would always maintain a relationship as parents with that child. The appellate decision in my case, the court ruled that the Johnson versus Calvert case was in a posit, that it didn't apply. And they jumped over backwards to reach that result. And what was very interesting about the appellate court decision were there were three judges in that hearing. White, Werdiger, and Chin. And what's interesting about Justice Chin and Justice Werdiger is flash forward to 2005, I'll get there in a minute, they were then on the Supreme Court of California, and they completely reversed what they did in 1994 in the case that I had. And so in the appellate decision in 1994, they wrote that the Johnson versus Calvert didn't apply to the case, and that the parties were unrelated, and if you only have one biological parent, that this other person who's an outsider, she's a non-entity, she's a nothing to this child, she's a zero to that child. They treated her as if she was a person off the street. No, she wasn't a person off the street, but that's the way they treated her in the ruling. And they said, if you're the biological parent and you decide the person off the street no longer should have a relationship with your child, then that's all well and good. The interesting thing about the Uniform Parentage Act and the law at that time, and one of the things I had to argue around, is that in a regular custody case in California, the standard that the court uses to evaluate whether parents continue a relationship with their children is always what's in the best interest of the child. In guardianship cases, it's a different standard. It's whether or not the parent of the child would harm the child if they continued the relationship. They would be a detrimental relationship, and therefore you would terminate the detrimental parental relationship in favor of this other relationship. And I said to the court, no, I'm not arguing that either relationship is detrimental. I don't want to say that the biological mother has a detrimental relationship to her daughter. She most definitely doesn't. Neither person has a detrimental relationship. What the court should evaluate here, and why I was asking for the change in the law, is both it is in the best interest of the child to maintain the relationship with both parents. In the Calvert case, when they look at the intention of the parties, and that's what I was arguing for in this case, if you look at the intention of the parties, they intended this relationship with their daughter. So 1994, my client loses that case. She lost everything. She lost her relationship with her daughter. It was devastating. It was awful. I don't know how else to express that. Then between 1994 and 2005, that's when the court changed, and they turned upside down. And if you read both cases, I brought them with me today in case you want some bedtime reading. If you compare the 1994 decision and then look at what Justice Chin and Werdiger wrote in 2005, relying on the same cases, relying on Johnson versus Calvert to reach the decision in the 2005 case that the women, and the fact pattern in that case is very interesting. It's the following. Two women get together, and they have two children. They are not married, and they're not registered domestic partners, which you could be at that point, but they weren't. One of them was a stay-at-home mom, and the other was the worker mom. And the worker mom took the two children as dependents on her tax returns. They held them out as their children. They acted like a family. They were parents, etc. The relationship ends, and the worker mother, non-worker mom, says, you need to pay some child support. Worker mom says, no, I have no legal relationship to these children. They're not my children. She mentioned the whole string of cases that stood for the proposition that if you're not a biological parent or a natural parent, you're a zero, and correspondingly, you owe no child support. So the DA Family Support Unit sued her, and that case goes all the way to the California Supreme Court in August 22, 2005. And as I said earlier, Chin and Werdiger are now on that court, and they rule that if you intend to bring a child into this world, and you hold that child out as your own, that you're going to be treated like a parent, and you, in fact, are going to owe child support. So they got to the right result, but it took them, 94 to 2005.
Can you tell me a little bit more, that day that the ruling came down against her client, and was she in court with you at the time?
Oh, yeah.
Okay, can you just tell me, from the time the judge said, ruled, and how your client, you reacted when you heard that? Can you kind of relay that?
So the day in court, that's not when we heard our ruling. Actually, I think the best part of this whole litigation, if there was one, was the appellate court hearing, because it was really the opportunity that we had to speak at some great length about her case and the change in the law that we wanted. And why that day I think was very powerful for my client was the courtroom was packed. There were amici briefs written by many different firms and nonprofit entities around the country. Everybody was there. It was a very supportive and it was a really powerful day. And we put our best foot forward and made a great argument. When we left court, my feeling was that I think the court was going to do the right thing. I'm a very optimistic person. I was hoping for that when I left. So it was some weeks later that we got the ruling. And when the ruling came out, those are public, so the news goes very fast, much faster today than back then. But when my client heard the ruling, she was devastated, just beside herself. So it was awful.
Was there a community response also?
A very large community response. So these two women were very politically active in this community. When their relationship ended, there were lots of people that had opinions about that, and there were certainly very strong opinions in favor of my client and against the other woman for keeping my client from her daughter. So the woman, the biological mother who made this decision, was ostracized. She was treated not very well.
And did the community do anything else? Were there any protests or any other kinds of actions, support kind of actions?
There weren't any, not that I'm aware of. I don't recall any.
So that was the final word at that time?
It was the final word. There were lots of articles in the press talking about the history of lesbian relationships and the results that we were having. By 2005, I think one of the reasons why the justices changed their ruling at that point was just the sheer number of people that were having children. I mean, we were seeing more and more couples that were doing this, and the law often does not keep up with science, and this was true here, that we didn't have any legal remedy for these relationships, and courts were seeing couple after couple come in, and they were finally getting to the point is they had to recognize these parents are critical to these children. And so if you create this fiction, and I said to the court, you're creating a fiction. This is you want to treat this person like she's unrelated to this child. That's a fiction. Don't do it. They did, until they didn't.
What is the definition of a parent and how does that affect their rights?
Back then, the definition, and this is in the Uniform Parentage Act, is you had to be a biological relationship to that child or a natural relationship. And I was like, excuse me, what does that word natural mean? So in 1994, natural meant my client had no relationship with her daughter. 2005, natural meant if you intend to do this and you act like it, then you're a natural parent. So vague and ambiguous is what I would say that word is, and could be construed, obviously, in both ways. So now, because of case law, it's really what your intention is. And so intention can be shown by your written agreements, and more importantly, shown by your behavior, right? So you could have a whole pile of witnesses come forward and testify. How did these people act? You know, did they treat each other like they were a family? Did they act like parents, and so forth? And one of the things in my case, I had a whole slew of witnesses I was going to call if I'd ever been able to have an evidentiary hearing. I asked for an evidentiary hearing, and that was denied. And in lieu of that, I did declarations. I had a whole ton of declarations from people who, under penalty of perjury, said, this is my experience, this is my direct personal knowledge of my experience with this child and these parents. You know, show the intention, and so what was going on in that relationship.
So let's move to the concept, so I'm sure you're aware of the Catholic Church recently had ruling in their favor to be allowed to discriminate against same-sex couples adoptions. Can you tell me your concern about going forward about these sites maybe rolling back?
My concern, it really goes to our separation of church and state, right? The constitutional issue there. And in my opinion, that ruling that just came out is ill-conceived.
Which ruling?
The U.S. Supreme Court ruling. In that case, where they're saying, basically that this organization can discriminate in these types of areas in adoption. And my opinion about that is great. You can do that if you're a private institution and you're doing that privately, but they're not. They're doing that in a public forum, and that's the difference. And what we've seen happen in this country in the last 20, 30 years is what used to be a separation of church and state is diminishing as we go by, and it's becoming more clouded, and certainly the religious organizations have a ton of constitutional power that they've been gathering that oppresses lots of people. And so to me, if you're getting government money and providing a government service, or here a private service, but they're getting some government money from that, no, go do that privately. Use your Catholic Church money if you want to go do that. But don't do that in a form that either taxpayers are paying for or otherwise. And of course, if I were advising somebody in adoption, I would say, don't go through the Catholic Church.
Okay, so can you summarize the case? So you gave us a really good detailed explanation. Can you summarize the case very succinctly? The important aspects of it, and then, like in about a paragraph worth of words to try and wrap it up in a, I know it's a complex kind of thing, but we're looking for kind of a general description.
If we could cut here, please.
What I'm looking for
Okay.
is like a summary of the thing.
B-rolls. Ready.
I would say the summary of what the case I was involved with really involved is who do we consider parents of children? And how do we structure that? And how does the law recognize it? So the law did not recognize that relationship back in 1994. And the law changed. And it changed specifically around intention, the party's intention. And to me, that's the right result. That and what's in the best interest of the child. And I never got to that argument with the court. And that's unfortunate.
Good, that's a good summary. Is there other areas of parental rights that you see needing changing or that are in danger of rolling back? Like the adoption one was one. They have bakers who don't want to make cakes. They have trans rights that they could no longer go into the army. And so when you get a conservative person in charge, there's a chance that they can roll back things. Is there any danger, or do you think of parental rights being rolled back, or marriages being rolled back, or?
I don't think in marriage, and I've been very involved in the whole litigation area for same-gender marriage. I don't think we will see that rolled back just because of the sheer numbers of people that have already been married, and it will be a colossal undertaking to do that. They could do it. They could say that everybody that was married still is married, but you can't get married in the future. I just don't think even our conservative court's going to do that. I think in terms of adoption, it really is state by state specific. It's the same thing with transgender rights and transgender access and the current fascination with where transgender people go to the bathroom. Remember when it used to be the way for lesbian and gay people, really for gay men more than lesbians. Oh, what happens if this person comes into the bathroom? oh my God, what is it with the bathroom? And we know what it is about the bathroom. It's not about the bathroom. It's because they don't have anything else right now to talk about politically, right, that they want to deal with. That's why the transgender thing is happening, in my opinion. In terms of lesbian and gay parenting rights in California, I do not think we're going backwards in California anytime soon. But if you're in the Deep South, or you're in a lot of those other states, I think that your relationships there, not your marital relationships, because now that's protected by federal law, but state law is what controls adoption, not federal law. So that is something that is a concern. And where that goes, I think, depends on what people do to continue to litigate in this area and make it public.
Okay, all right.
Ready?
Okay, so let's start back with the, what you're going to say.
So where I think we are as a society and a culture in the U.S. has to do with voting rights and whether we see some of our hard-won rights that we have today, right? The right to marry. Our relationships in California are now more secure than they ever have been, both in parental relationships and in marital relationships and domestic partnerships. But if we don't maintain the right to vote, we will lose all of that. And the reason we could lose it all is because it's the legislature that makes these laws. And historically, those laws prevented any same-gender couples from adopting. That was a real stretch that took a long time, just like our marital rights took a long time. And legislatively, those were all found unpermissible. And it was the social changes that happened over time, and actually the vote, go to the polls. California has had some very negative propositions. You might remember there was one back a zillion years ago that was against the teachers, right? If you were a lesbian and gay teacher, you couldn't be a teacher. So we need to maintain the right to vote so that we can control who our representatives are and ideally have people there that reflect the majority of the citizenry, separate from what we're seeing right now, which is in many states, you have a minority of people that are controlling that legislative process. What are they doing right now with all the restrictive voting rights, right? They're trying to take those away from all of us, not just one group of people, but all of us. So to me, voting rights is critical. Without that, you don't get to any other issue. You're stuck if we don't have the right to vote and say who you would like in office.
Where they are now.
Eleanor and Georgia. Okay, so the two clients,
And
can
the
you
other
tell them?
mom,
We'll probably get some of that from Georgia too, but. let's-
Yeah, I don't know where they are now. I mean, I know where, are we on? Because
Yeah.
I don't want to mention the name. So my understanding about their daughter is that she's back east. And Georgia, as far as I know, is in Sacramento. I don't know where the other person is.
But
Yeah.
they're no longer in contact with each other.
No, as far as I
Can you
know.
say that in a complete sentence?
That
They're no longer in contact with each other. The biological mother and the mother are no longer in
as
contact
far as
with
I
each other,
know,
As far as you know.
yeah.
the child, yes.
as far as I know, where I left off, my client had no contact with her daughter, and the biological mother and the daughter resided over, and I believe it was over in the Davis area for some period of time. I don't know what happened after that. So I don't know where they are today.
Okay,
I think we're good.
that's good.
Excellent.
Thanks. You never identified yourself on camera. Maybe you could do that. Just say who you are, how your name is spelled.
My name is Karen Callahan, spelled with a C, C-A-R-E-N, and last is the natural spelling of Callahan, without the G or the O.
And do you want any,
Like a title?
Title?
What would you like your title to say?
how would you like your title to read? Your name will appear on the screen.
What would I say about that? Lesbian activist attorney.
Lesbian comma or just lesbian activist attorney?
Yeah, with a raised fist, please.
Cool, that's great.
Wonderful.
Thank you. Thank you
That
so
was-
much.